Thanks for coming. I'm not surprised that I got a slightly smaller crowd for this because not that many people know who John Marshall Harlan is. My next one of these is Oliver Wendell Holmes, and I bet I'll get more people for that just because there's a lot more name recognition. I'm John Foster. I've seen the vast majority of you, but so still I forget to say sometimes who I am or why you should care what I have to think. The second thing is a harder issue to resolve in any case, but I'm a reference librarian up here at the Manor Public Library, and those of you who are habitués of the library will have seen me kicking around the reference desk, because if they didn't close, I probably would never leave. You know, I decided I was going to do this series. I do a series every year, most of you probably know, and a lot of times it's the sort of underlying rationale for doing it is I want an excuse for reading some books about something that I don't really know that much about. So the first year I did military history, which I know sort of something about, but not a huge amount. The first one I did was the Battle of Midway, which I really enjoyed, although I really learned how little I knew about naval warfare. In any case, maybe I'll walk back in frame for the sake of long-suffering Jason Lee. So this time I thought I would this is the first of my sort of two-part thing on Supreme Court justices. I'm going to do another one maybe next year just to sort of rebuild the attendance numbers. I might just start doing, who was it? I was talking to somebody upstairs and they were like, yeah, you didn't have that many signups. And I'm like, well, my next series I'm doing something with a bigger body count because that's, not to put too fine a point on it. This is one of the things we were talking about earlier, the sort of unfortunate aspect of being next to the James A. Garfield Historic Site. And I love James A. Garfield. Everybody who works there is really fabulous. Todd Arrington, the head ranger, is one of my absolute favorite people in the world. He's just a sweet guy. Later on this year, I think in October and November, we're doing a two-part collaborative program on 1863. We were going to do something about Gettysburg, but then it turned out that he was already doing something about Gettysburg, and that also Alan Gephardt is doing something about the Gettysburg Address. So that kind of cut down the range of things we could do. But so we thought we would sort of talk about what was going on in 1863 and why that was a sort of interesting point in American history. But in any case, the rationale for doing this was partly that I was kind of interested in law, but kind of wanted to read more books about it, which I have certainly now done. And I have great respect for people who are lawyers because it involves a kind of sort of fascination with minutiae that's really profound. I mean, even bad lawyers have to be fascinated with minutiae. They just get fascinated with the wrong kind. In any case, John Marshall Harlan, I'm not surprised that I didn't get huge numbers for this, and here's the reason. John Marshall Harlan was forgotten for quite some time. He was very much out of step with a lot of the Supreme Court while he was on it. And he offered, there's a biography of John Marshall Harlan that came out last year called The Great Dissenter. And it's a very apt title. This is where I get the title for my thing here too. And it's because, in a certain sense, his influence on what you might call positive law, that is to say on how the law came to be, was kind of delayed. Most of his famous legal utterances, if you want to call them that, came in dissents, and especially in the 1896 Plessy v. Ferguson decision, which was one of the most profound and, in fact, sort of wrong-headed decisions in the history of American jurisprudence, and which he very much got right, although his rightness in that case was not really acknowledged until the 1950s. And so that's, I really feel like I want to sort of do my bit to regenerate the reputation of John Marshall Harlan. Also, and this I was mentioning to a couple of the people sort of earlier on as people were assembling, John Marshall Harlan was one of these guys who had a real sort of intellectual change of heart in his 40s. That's fairly rare. Usually by the time you get to your fifth decade of life, you've really become pretty fixed in your ways intellectually. It's fairly rare. If for no other reason than if you change a big idea that you have, you're like, oh my God, I wasted so much time with that wrong idea. Like, it sort of has an intrinsic momentum to get you not to do it. But he grew up in a family that owned slaves. He had a half-brother, Robert Harlan, 16 years older than himself, who was the result of his father's liaison with a enslaved woman. It's not clear, and it wasn't the kind of thing that people tended to talk about very openly. There's an interesting moment, and a line written by a Confederate diarist, I think it's Mary Chestnut, but I can't remember off the top of my head, about the sort of mixed race, the tendency to produce mixed race children in the Southern slave society. And whoever this was, it may have been Mary Chestnut, wrote that the mother on every plantation knows the parentage of every mixed race child on every plantation in the district except her own. And it was just one of those things that just was not talked about. It wasn't proper to talk about. But anyway, he did have this brother, Robert. And Robert was effectively free for a lot of the time before the Civil War, and then actually free after that, and was very active as a racehorse entrepreneur and very active in politics down in Cincinnati. He served in the state legislature for a year in the late 1860s. And they were in contact and knew each other. But the sort of the life trajectory of Robert Harlan was very much different than it was for John Marshall Harlan. You will notice, probably pretty quickly, that John Marshall Harlan is named, his name has a suspicious similarity to the name of the fourth Chief Justice of the United States, John Marshall, and this was not an accident. His father, James Harlan, who was a lawyer, named him after John Marshall. I think he was the fourth of 5 children. I should have written that down, but it's not a key fact. He was a younger son, but or I think he was the 5th, and the reason was that his 4 older brothers were also lawyers. But if you're named John Marshall something, chances are you're not going to end up as a certified public accountant or whatever. I mean, it's one of those things where the name you get kind of leads you into the life that you live, although not in every case, certainly. My name is John Foster. I was not named after John Foster Dulles. The very suggestion probably would have caused my father to burst into flames, and it did not cause me to go into public service, except at this very low, I shouldn't say low, but at this sort of street-level librarian gig. The Harlan family, they lived in Kentucky. One of Mary Todd Lincoln's cousins married a man named Harlan, not from this family. They were from Iowa, I believe, or Indiana, one of the vowel states that wasn't Ohio. But James Harlan was active in Ohio. I've got Ohio on the brain now. In Kentucky politics, he was a member of the U.S. House of Representatives for 4 years in the 1830s. He was the Secretary of State from 1840 to 1844. He was the Attorney General from 1851 to 59. He was associated with the Whig Party. And the Whig Party is often forgotten in the United States. The Whigs were, of course, they took their name from the British Whig Party, which was the more liberal of the two parties in the United Kingdom. The American Whig Party was a sort of conservative party that was formed in the 1830s and meant to be a kind of counterweight to the pro-slavery Democratic Party. The Whigs, in a certain sense, are the precursors to the Republicans, although it's not like one led to the other. It was one collapsed and the other sort of took up their voter base. But the Whigs tended to be relatively anti-slavery, but not aggressively abolitionist mostly. And there was, in this period between the start of the 19th century and the beginning of the Civil War, I think it's fair to say that the question of slavery, the question of abolition, was the central question moving a lot of American politics, not all of it, but a lot of it. So that, for instance, the Mexican War that breaks out in the 1840s has a lot to do with Mexico, which had controlled the Texas sort of territory, was not a slave area. Slavery was not permitted in Texas. There were a lot of people who wanted to annex Texas. Texas had become, in practice, an independent republic. There were a lot of people who wanted to annex Texas in the South. And this has to do with the sort of larger direction of cotton growing. So if you've seen earlier lectures in this series or some of the ones I did last year, cotton was moving west. Cotton is soil exhausting. So it has to keep moving. By the beginning of the Civil War, 90% of the cotton grown in the United States was grown west of the Georgia-Alabama line. And it was moving westward. And so that's why the question of what's going to be a slave state out west becomes a big issue for people. So by the way, this is James Harlan, John Marshall Harlan's father. This is Robert Harlan, his brother, in sort of later life, as you might expect. He was born in Boyle County, Kentucky in 1833, John Marshall Harlan was. He went to Dissenter College, and then he went to Transylvania University. I didn't sort of distinguish. And the interesting thing about Transylvania University is not that it's called Transylvania University, but that he went to law school. And that was relatively uncommon. In those days, if you were going to be a lawyer, it was more often the case that you would do as Abraham Lincoln did. You would just read some law books and work as a clerk in a law office, and then eventually you would pass the bar and you would be admitted. But his father, this is an indication of how much his father wanted him to be not just a lawyer, but a lawyer, like an important lawyer, was that he sent him to Transylvania University. This is all in Kentucky, by the way. This is Center College in Louisville. So this is where Harlan was born, in Harlan Station. His family was pretty well known in that part of Kentucky. Kentucky was, when the Civil War came around, was a border state. And there was a lot of very powerful feeling on both sides of the abolition question in Kentucky. There were some very passionate abolitionists in Kentucky. There were some very prominent pro-slavery people in Kentucky. And Harlan and the Whigs, with whom he and his father were associated, they were partisans of Henry Clay, the great politician from Kentucky, whose compromise in terms that sort of said that Kansas and Nebraska would come in. They would have a plebiscite to decide whether they were going to be free or slave states, which had horrific results in terms of the outbreak of armed violence by partisans of both sides. Some truly unbelievably horrible massacres, including one committed by John Brown at Pottawatomie Creek, where they just hacked several people to death with swords. But Harlan and his family were they were slave owners. They didn't own a huge number of slaves, but they were slave owners. What they thought was that some sort of compromise had to be come to. They thought that both sides were extreme, and they were trying to sort of find a middle ground. And what ended up happening was that the Whigs eventually sort of collapsed in the 1840s, partly because they don't have a sort of consistent policy. This is Henry Clay, that's Daniel Webster, that's Zachary Taylor, and I think I have this picture in here. This is an available candidate. It's sort of a joke about the Whigs, because this could be Zachary Taylor, or it could be Winfield Scott, both of whom fought prominently in the Mexican War. But you can see they're sitting on top of a pile of skulls, and this is an anti-Whig poster, the point of which is that the Whigs are associated with kind of military expansion and keep sort of tying themselves to the fate of generals. But this is the sort of outcome of the Mexican War. So we get sort of Texas, but we also get large portions of westward territory. And this once again puts the question of slavery and where slavery is going to expand to on the map, so to speak. I talked last time about John Marshall and the question of slavery. If you look historically at the question of slavery, right, there are some people who got it. Okay, so there's Alexander Hamilton. Alexander Hamilton, we know from his account books, may have engaged in a few slave trades here and there, mostly for other people. But he was involved in the New York Manumission Society. And he actually said on a number of occasions that he really thought that black people had the same capacities and human dignity as white people, which is a fairly rare opinion to be holding back then. Jefferson at least got Jefferson famously said that slavery was like having a wolf by the ears. You didn't really like it, but you didn't like the alternatives very much either. Washington manumitted all of his slaves when he died and refused to engage in any slave dealing after the Revolutionary War, saying that he didn't want to engage in a trade where human beings were treated like cattle. John Marshall, unfortunately for human civilization, ruled against enslaved people in pretty much every instance that they came in front of him, and in a number of cases clearly ignored the actual black letter of the law to rule against them, which is why, I was talking to one of the attendees of the last lecture who was troubled by the Cleveland State Law School removing his name. And I think that's why. It's one thing, we don't want to sort of necessarily project our views back, but clearly he had an agenda and he took material actions that had unfortunate consequences, so I think that's why. But people want to talk about that, we can talk about it afterwards. I just felt like, because we're talking about someone whose name is also John Marshall, that probably it should be discussed. I'm not going to go too much into the Mexican War. It's just a matter of, this was part of the collapse of Whiggism. And so John Marshall Harlan, as the Whigs sort of collapse, and as it becomes clear that Henry Clay is not going to be the president, Henry Clay was the sort of favored candidate of the Whigs, he joins the Know Nothing Party. The Know Nothing Party was a party that existed in the United States in the 1830s, 40s, 50s, whose position was anti-Catholic, anti-foreigner, but also sort of moderate and sort of compromising in a lot of respects. I mean, they were roughly speaking pro-slavery, but they were more, I shouldn't say pro-slavery. They wanted to sort of resolve the question through compromise, unlike the Democrats, who were responsible for a number of initiatives like the gag laws of the 1830s that said that it would be illegal. It was illegal for a period between, I think, 1831 and 1834 to actually advocate abolition. Congress passed a series of laws that made that illegal because it was the slave owners argued it was an attack on their property rights. Finally, I think they saw the letter of reason, I think in 1834 the laws were repealed. But the Democratic Party in those days was very unapologetically pro-slavery, pro the expansion of slavery, pro the justification of slavery. And this is something that Harlan is really worried about, because he thinks it's going to tear the country apart. Harlan is another one of these guys who's a very pronounced nationalist. And what he wants is a compromise that's not going to tear the country in two. Now, it's debatable. You can look at politics in the 1850s and be like, well, that's, I want lots of things, but, many of them are just not going to happen in this world. And obviously, reading back from what happened in the 1860s, you can look at people in the 1850s who were trying to find some sort of middle road between the two and say, well, that was never going to work. Eventually, Harlan gets kind of turned off by the anti-Catholicism of the Know-Nothings, and also by their propensity for violence. There's an event that happens in Kentucky where a group of Know-Nothings attack the Irish section of town. There's a gunfight. I think, something like 20 people end up getting killed over the course of several days of rioting. He eventually is involved in what's called the Union Party. Once again, this is not Union versus Confederacy, because that doesn't exist yet, but it's a party that's the central sort of proposition of which is, let's find a way between these two extremes so that the country can stay together. He has some sort of qualms about slavery, but he thinks it's a system that can persist. But ultimately, he's pro-Union. So when the Civil War breaks out, he joins the Union Army. He becomes the commander of what becomes the 10th Kentucky Volunteers, and they're an infantry regiment. They end up going to a lot of interesting places, mostly coming around slightly after the shooting stopped. Like they get to Pittsburgh Landing, i.e. Shiloh, the day after the really nasty bits have gone on. He ends up walking around the battlefield where there's still like corpses lying everywhere, and writing letters home about how horrific that was. But he's very much liked as a commanding officer. He's a very physical guy. He's big. He's about 6'3". And he's a kind of soldier's commander. His men really like him, but he's a good, he maintains good discipline. 1863, his father dies, and he ends up writing a letter to General Rosecrans. Well, not to General Rosecrans, to his adjutant, a certain James A. Garfield, who eventually achieved fame, basically saying, I wish I could keep serving, but there are all these things going on at home, and I have to resign my commission. Obviously, I'm still a supporter of the Union. And he goes back to take over his father's affairs in Kentucky. At this point, too, he's a lawyer, and he's not making that much money. He doesn't really have, a gigantic practice. But this, too, is this sort of weird period where, around when Lincoln issues the Emancipation Proclamation, which Harlan thinks is a terrible idea. And the Emancipation Proclamation, you can sort of argue about it because it didn't really free that many slaves. Viewed one way, it didn't free any slaves, because it basically said, you'll remember if you've read the text, that it freed slaves in any place that was currently in rebellion, right? So that didn't include the border states like Kentucky or Maryland. But the Southerners are really horrified by this too, right? Because if you're Southern, you read the Emancipation Proclamation and you're just like, my God, you're inviting the slaves to murder us in our beds. Let's, that they should be inclined to do so never really comes, or why they might be inclined to do so never really sort of darkens your countenance. But Harlan didn't think it was a very good idea. So, and the reason I keep adverting to this about Harlan is that he later on really reverses himself on the question of black equality and the rights of black people. He always maintains a sort of idea that the white race is superior, but not intrinsically. We'll get into this in his Plessy decision. But he really changes his ideas about the equality of the legal equality of black people, and that's something that I think is really pretty remarkable. It's fairly. A lot of those guys after the Civil War thought exactly the same thing on the day it ended as the day they started, and thought the exact same thing, 30 years later. So he joins the Republican Party. Once again, he's not really comfortable with the whole strongly abolitionist tone of a lot of Republicans. But, you could look at, not everybody was convinced that the Republicans were that committed to abolition. And there's that famous moment when one of the Boston abolitionists referred to Abraham Lincoln as a first-rate, second-rate man because he didn't think that he was really promoting abolition with the, and there were some very passionate abolitionists, and it was a kind of thing that could really get you killed. People were very, the question of abolition was very hotly debated to the point of actual violence. So after the war ends, there's Reconstruction, right? So the Union troops are still in the South, and then there's this election after Grant's presidency when the country is still very heavily divided. And particularly in the South. This is before Jim Crow, so black people can actually vote in the South. This is, one of the big changes that goes on in the South is the rise of the Jim Crow system after the end of Reconstruction. So that, you'll notice, I don't have it in this, but I have it in the PowerPoint for a talk I gave a couple of weeks ago, that there's a chart you can find online that shows when all the statues were built. And there's a big, lump about yay high between 1890 and 1904, when there's no more Reconstruction, the locals are free to prevent black people from voting, and they put up all these statues of, Robert E. Lee and Nathan Bedford Forrest, a founding member of the Ku Klux Klan. Up until very recently, there was still a statue of Nathan Bedford Forrest in Richmond and probably elsewhere. And this is a weird moment. We'll get to this a little bit more later, but this is a moment at which, these people are traitors. Even if they very passionately believed in what they were fighting with, everybody thinks they're a good person. Even Hitler thought he was basically a good person. Not to compare these people to Hitler, obviously, but what I'm saying is that, it's not like in the comic books where you're like, we're part of the Brotherhood of Evil. Nobody's sitting around going, I'm really a terrible person. I know it's not politically correct to say so, but I'm a horrible person. The fact that Lee and Stonewall Jackson and all these people believe passionately in their cause is really neither here nor there. They were, let's be clear, traitors. So the fact that these statues are getting put up in the 1890s, it's not about history. If you want to read history, there are books. It's about making the point. This is at the same point that black disenfranchisement is happening. So why am I telling you this about John Marshall Harlan? Well, eventually Rutherford B. Hayes gets elected. As a matter of fact, John Marshall Harlan is on the commission that gets sent down to Louisiana to decide which of the two slates of electors are going to be the legit one. And the governor of Louisiana, who's a Reconstruction guy, is basically almost a prisoner in the governor's mansion, him and his staff. And finally, there's a sort of agreement struck. Harlan, when he gets put on this commission, is like, oh my God, what? This is no good thing comes out of this. I really don't want to, but he felt obligated to do it. Anyway, so finally the situation gets worked out. The governor and his staff, who are very unpopular, end up clearing out. But when the Southerners go in there, the new administration goes in there, there's graffiti all over the walls, and somebody has written on the wall in the governor's mansion, Rutherford Bastard Hayes. And that's not all. That's, I think, probably one of the more sort of family-friendly things that that got written on the wall. And it was because they knew that Hayes was basically pulling back Reconstruction. And this is key, because there's this period after the Civil War when things really change in the United States, right? So we get the post-Civil War amendments, 13, 14, and 15. By the way, I've mentioned this at some other talks, so some of you have already heard my spiel about this. You know, if you want to argue who the greatest Ohioan is, there's a number of candidates, but my dark horse candidate, if you want to say, is John Armour Bingham, who was a congressman from, I think in Warren County, but I'm not 100% sure. But he was basically the author of the 14th Amendment. And he actually voted against the Civil Rights Act of 1875 because he thought that it didn't go far enough. In any case, so we get 13, 14, 15. 13 says no more slavery, except for people in penal servitude. 14 is maybe the most, or one of the most interesting parts of the U.S. government. So you get the Equal Protection Clause, right? Everybody is entitled to equal protection of the law. And weirdly enough, what may be even more influential in our current lives, you get the Due Process Clause, which is that and some stuff in the Sixth Amendment is kind of the basis for substantive due process. I may give a whole lecture at some point on substantive due process. I'll get about 5 people to come here. You two will probably be them. And then you get 15, which is voting rights. And by the way, this is another interesting thing. 15 doesn't say black people get the vote, the 15th Amendment. 15th Amendment says if anybody gets the vote, everybody has to get it. But you don't really, there's a really sort of weird thing about your constitutional, voting is now a constitutionally guaranteed right. But that kind of doesn't happen until later. And even the 15th Amendment really just says if some people get to vote, then everybody does, which leads into a whole other kettle of fish. So there's John Marshall Harlan. When he first got on the court, he really was pretty deferential to the.
Is Hayes the guy who puts him on the court?
Hayes appoints him to the court in the final days of the Hayes administration. Most of the other, or a lot of the other lawyers on the court, a lot of the other judges on the court, are former corporate lawyers. And there tends to be a very pronounced pro-corporate slant, especially as things go on. This is what eventually becomes the Lochner Court. We'll talk about Lochner toward the end of this. The Lochner decision is one of the sort of defining features of the court up into the early 20th century. But at the beginning, he goes with the flow, mostly. But what happens after the passage of the Civil Rights Amendment is almost immediately, I'm going to say this again. What happens after the passage of the post-Civil War Amendments, 13, 14, and 15, and then of the Civil Rights Bill of 1875? Why is my brain not coming up with this? 1875, Civil Rights Act of 1875. What you get is the court trying to sort of draw back from this idea that what was really going on was a situation of racial equality in the United States. So that, first of all, you get a sort of argument about whether, partly what's going on here is incorporation, right? So to begin with, 13, 14, and 15 are very different than the amendments in the original Bill of Rights. Why? Because if you look at the original Bill of Rights, the language is almost invariably, Congress shall make no law doing such and such a thing. A clause is appended to all 3 of the 13th, 14th, and 15th Amendments says, Congress may pass such laws as are necessary to make this happen, right? So this is something that's, there's a big change going on, and it's kind of based on the necessary and proper clause of Article 1, right? So that's, Alexander Hamilton famously says in the debate about whether it can be a national bank, right? So George Washington said, should we have a national bank? Alexander Hamilton writes a 60-page, treatise on why we should have one. Then Thomas Jefferson reads it and says, well, no, the Constitution doesn't say we can do that. And then, so Alexander Hamilton writes another, even longer treatise, the substance of which it's called On the Constitutionality of a National Bank, in which he basically says The necessary and proper clause means that the government can make whatever laws. So if such a thing is necessary, whatever it is necessary, the government can make whatever laws to make it happen as long as they don't conflict with something explicitly prohibited by the Constitution. And also, by the way, and this is really standard Alexander Hamilton, he includes about a 4 or 5 page long explanation of what the word necessary means. Like, just in case you were unclear about, necessary is like pregnant. It can't be sort of necessary. It's either necessary or it isn't. But in any case, then John Marshall takes this up in McCulloch v. Maryland, in which he basically says, look, once again, the Constitution, nowhere in the Constitution does it say we can have a national bank or the government should start a national bank, but having been determined to be necessary, the necessary and proper clause covers that. So that's why we got it. Sort of overlapping with this is incorporation. So it's not clear, and this will come up a lot in this, that the Bill of Rights, the amendments in the Bill of Rights, and subsequently also the amendments in the Civil War amendments, apply to anything but federal law. So for a long time it was viewed, starting in the 1830s, that the Second Amendment, for instance, only applied to federal law. So the states could make whatever laws they wanted that wouldn't be subject to Supreme Court review for constitutionality, because, they would be subject to constitutional scrutiny for stuff that's in the original Constitution, not for stuff that's in the Bill of Rights. So the states could make laws that weren't consonant with that. The federal government couldn't. So what happens is a process of the Supreme Court kind of trying to draw back the scope of the Civil War amendments. The text of the Civil Rights Act of 1875 runs in part like this. Whereas it is essential to just government, we recognize the equality of all men before the law and hold that it is the duty of government in its dealings with the people to mete out equal and exact justice to all of whatever nativity, race, color, or persuasion, religious or political, and it being the appropriate object of legislation to enact great fundamental principles into law. Therefore, be it enacted that all persons within the jurisdiction of the United States shall be entitled to the full and equal enjoyment of the accommodations, advantages, facilities, and privileges of inns, public conveyances on land or water, theaters, and other places of public amusement, subject only to the condition and limitations established by law and applicable alike to citizens of every race and color, regardless of any previous condition of servitude. So what does that mean? That means if you're running an inn, that's essentially a public facility, even though it's your private property. So according to this, you cannot refuse service to somebody because they're black, because they're Catholic. Theoretically, you could do it because they're a woman, but that only gets sorted out later on. Sorry, ladies. This is another kind of funny thing. I'll talk about this at another more appropriate point, but the suffragettes, Susan B. Anthony, Elizabeth Cady Stanton, sort of pulled back their agitation for women's suffrage in the era right after the Civil War and started agitating for black suffrage. Because their view was, if you give black people the vote, of course you're going to give women the vote, which turned out not to be the case, much to their annoyance. And Susan B. Anthony said some things probably that in the better angels of her nature might have inclined her not to say, because she was very frustrated that once, James A. Garfield, there's a really funny letter, Todd Arrington quotes this all the time, where Lucretia Garfield points out to James A. Garfield, hey, black suffrage, women's suffrage, right? And James A. Garfield is like, let's not get crazy. It's clear that what's going on is this process of trying to sort of pull back what's involved. I'm going to pass over some of these early cases. But he was involved in Pace versus Alabama. Does anyone know here what Pace versus Alabama was about? It meant that there was an anti-fornication law or an anti-cohabitation law, and it meant that it was okay for the states to sentence you to longer terms or or bigger penalties if it was an interracial couple. So that, and this could be like 2 to 5 years in prison. They were serious about this stuff. So what comes up in the 1880s is what's called the civil rights cases. The civil rights cases are an amalgamation of 5 different cases, one of which involves a black man in New York trying to get into a theater, one of which involves a woman trying to get on a train car. And it's basically an attempt to see whether the Supreme Court will actually defend the rights which are enumerated in the Civil Rights Act of 1875. And that's when that question of whether the things in the Bill of Rights applied to, and the amendments to the Constitution applied only to federal law, or whether they applied to state law as well. So there's kind of 2 levels that we're going to talk about. There's that, and then there's the question of does it apply to private people, right? So one question is, can we make a law? Does the Constitution say that state laws are subject to constitutional scrutiny? And the second one is racism subject to constitutional scrutiny? And they're 2 separate questions that Harlan is part of the adjudication of, although they get re-adjudicated later. I mean, I think that there's one sort of way of looking at this that says, like, they were adjudicated incorrectly in the 1880s, and then in the 1950s and 1960s, they were re-adjudicated correctly. Although, just to give you, for instance, and once again, I try very hard not to preach politics from the lectern, because if you want to hear my political views, we can go across the street to BJ's, and you buy me a pint or 2, you can hear all you want and more of my political views. But I mean, the interesting thing about the Civil Rights Act in the 1950s is that it's based on a kind of tendentious reading of the Interstate Commerce Clause, right? So basically the argument of that piece of legislation is, if black truck drivers have to drive things into the South, they can't find a hotel to stay at, right? That amounts to a restraint of trade, because they can't really do the trade thing that they're involved in. Personally, I think that, just as a matter of personal opinion, I think that that's a correct. The legal reasoning behind it is a little questionable, but I think it's a correct outcome vis-a-vis what the Constitution and the promises to people, right? That, we hold these truths to be self-evident, that all men are created equal, which is the Declaration of Independence, I understand. But that, as a matter of fact, that they also look back to that. I mean, in the debates about slavery in the 1850s, 1860s, and after the Civil War, they are looking back to that and to the preamble of the Constitution: "We the people, in order to form a perfect union, establish justice, ensure domestic tranquility, provide for the common defense," etc. These things are viewed as part and parcel of the actual Constitution. And the same way that, Todd Arrington pointed this out, when Lincoln gets up and says 77 years ago, what is he talking about? He's talking about the Declaration of Independence. And he's making the point that the sort of opening segment of the Declaration of Independence is also a valid part of the national provenance, if you will. The court's opinion, which was written by Justice Joseph P. Bradley, was that forcing people to, or viewing the Constitution as not permitting people to limit who was going to go into their places of business was an overreach. It would be running the slavery argument into the ground to make it apply to every act of discrimination which a person may see fit to make as to his guests, as to guests he will entertain, or as to people he will take into his coach or cab or car, or to admit to his concert or theater, or deal with in other matters of intercourse or business, intercourse being trade here. Innkeepers and public carriers, by the laws of all the states, so far as we are aware, are bound to the extent of their facilities to furnish proper accommodation to all unobjectionable persons who in good faith apply to them. If the laws themselves make any unjust discrimination amenable to the prohibitions of the 14th Amendment, Congress has full power to afford a remedy under the amendment in accordance with it. When a man has emerged from slavery and by the aid of beneficent legislation has shaken off the inseparable concomitants of that state, there must be some stage in the progress of his elevation when he takes the rank of a mere citizen and ceases to be the special favorite of the laws, and when his rights as a citizen or a man are to be protected by the ordinary modes by which other men's rights are protected. So basically here he's saying, and I don't think that you have to be a particularly deep reader of this text to see this, no special rights for the released slaves. Like, okay, we've gotten rid of slavery. Sure, there's racism in the country. You just have to deal with that. There were thousands of free colored people in this country before the abolition of slavery, enjoying all the essential rights of life, liberty, and property, the same as white citizens. Yet no one at that time thought it was any invasion of their personal status of free men because they were not admitted to all the privileges enjoyed by white citizens. God, there's so much here. This has a very odd, okay, so just because, I think that that's untrue. I think that last statement is factually untrue, but even if it weren't, maybe there are some reasons why they didn't want to make a stink about things, even though they perceived them as unjust. And this is, this is in the kind of wake of Dred Scott, the notorious Dred Scott ruling in which Roger B. Taney, the Chief Justice of the Supreme Court, basically said that that blacks could not be citizens. And he says, it's unequivocally clear that the Founding Fathers meant that blacks would not be citizens. He offers absolutely no evidence that this is the case. And it is in fact not true. It's much more complicated. I really recommend the Klarman book, the Founders' Coup, if you're interested in finding out how the Constitution of 1787 was put together. There was a lot of variation of ideas. Interestingly, I think that the word citizen turns up in the U.S. Constitution, as it was at that point, something like 17 times. It is defined 0 times. And that's another interesting peculiarity. Like, what are the rights of a citizen? What is a citizen? And it's one of those things that I think that they didn't define because they all assumed that they knew it, right? I wouldn't define chair in some document I was writing because I'm assuming that anybody here knows what one is. And I think that the sort of variety of that came out in the Constitution. Harlan disagreed, and he wrote, and I think this is one of his more powerful dissents. The opinion in these cases proceeds, as it seems to me, upon grounds entirely too narrow and artificial. The substance and spirit of the recent amendments, that is the 13th, the 14th, and 15th, of the Constitution, have been sacrificed by a subtle and ingenious verbal criticism. It is not the words of the law, but the internal sense that makes the law. The letter of the law is the body. The sense and reason of the law is the soul. Constitutional provisions adopted in the interest of liberty and for the purpose of securing, through national legislation, if need be, rights inhering in a state of freedom and belonging to American citizenship, have been so construed as to defeat the ends the people desired to accomplish, which they attempted to accomplish and which they supposed they had accomplished by changes in the fundamental law. By this I do not mean that the determination of these cases should have been materially controlled by considerations of mere expediency or policy. I mean only, in this form, to express an earnest conviction that the court has departed from the familiar rule requiring, in the interpretation of constitutional provisions, that full effect be given to the intent with which they were adopted, okay? It is clear, and I mean, if you look at the debates surrounding the 13th, 14th, and 15th Amendment, that what they were aiming at was black equality. They weren't aiming to eliminate racism. I mean, every one of them conceded that, or let me rephrase that. Most of them had that as a goal. Some of them didn't. But most of them assumed that that was one of those things that was going to have to get worked out over the course of time. That the Constitution, there's some problems that the Constitution can't fix, right? And this is why, this is another thing that gets back to the point that Hamilton made about the Constitution. The Constitution isn't meant to resolve every issue. It's not meant to address every case. That would be a law code. A law code comes closer to addressing every case, although there are some things that the law doesn't resolve one way or the other. But the Constitution is meant to be a sort of more general statement. Anyway. The purpose of the first section of the Act of Congress of March 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, 1875, was to prevent race discrimination. It does not assume to define the general conditions and limitations under which inns, public conveyances, and places of public amusement may be conducted, but only declares that such condition and limitations, whatever they may be, shall not be applied by way of discrimination on account of race, color, or previous condition of servitude. Once again, women are signally left out of this. The second section provides a penalty against anyone denying or aiding, inciting the denial to any citizen that equality of right given by the first section, except for reasons by law applicable to citizens of every race and color, regardless of any previous condition. The court adjudges that Congress is without power under either the 13th or 14th Amendment to establish such regulations, and that the first or second sections of the statute are in all parts unconstitutional and void. So basically his position is that the common procedure has been, what was the intent of people behind the law? And clearly he's arguing, and I think he has good foundation for this, that the people who put together the 13th, 14th, and 15th Amendment did think that being denied the use of public service was what Harlan calls in another place the signs and badges of slavery, of servitude, right? And this will come up again later on, because in this process, the court this is a dissent, right? So this is Harlan saying the court has ruled this way. Yeah, Harlan was the only dissent on the court. Why do they have dissent on the Supreme Court? They didn't have it really in John Marshall's day. John Marshall's day, they all lived in the same rooming house in Washington when the court was in session. They took their meals together. They would discuss cases together, and then usually John Marshall would write the decision, and usually it was unanimous. It wasn't until later that you started to get, there was a dissent in the Dred Scott case. I suggest to everyone to read it because it really gets to exactly the things that are wrong with Dred Scott. But this comes up again in what turns out to be Harlan's most profound dissent, and it's in the case of Plessy v. Ferguson, 1896, am I right? Plessy v. Ferguson came about because an organization in Louisiana wanted to challenge the Louisiana state law that allowed separation of conveyance, so separate cars for blacks and whites in trains. And here's an engraving, I think this was from 1856 actually, and it's of a black man being ordered to leave a train car. You can see a nice blonde-haired, blue-eyed woman with her blonde-haired, blue-eyed child, and the guy looks like a little bit of a, he's very agitated, and here's the black guy with his bag just being like, hey, what? So Plessy got on the train car. Plessy was a very light-skinned black man. Nonetheless, he was sort of told he had to go. And I think that it was like $20 fine or 2 years or a year, $20 fine or a month in just something like that. I forget what the $20 is a lot of money in those days. I mean, what? That's Plessy. Right. I mean, he kind of looks like James A. Garfield. Just as black and white obviously doesn't necessarily catch exactly all the... So once again, when this gets adjudicated, it gets referred back to the civil rights cases. The majority decision, once again, goes like this. So far, then, as conflict with the 14th Amendment is concerned, the case reduces itself to the question of whether the statute of Louisiana is a reasonable regulation, and with respect to this, there must necessarily be a large discretion on the part of the legislature. In determining the question of reasonableness, it is at liberty to act with reference to the established usages, customs, and traditions of the people, and with a view to the promotion of their comfort and the preservation of the public peace and good order. Right? So, what are the bases for this? Well, so there's they don't mention the whole race mixing thing, and one of the things that the Southerners had been sort of touting ever since the 1830s was, well, what the abolitionists want is for your daughter to be forced to marry a black man. And it sounds kind of absurd when I say it out loud, but that was part of their rhetoric, and it was part of their rhetoric even up into the early 20th century. So this is the nice way of phrasing that, if you will, the family-friendly way, in which you say, well, people have their customs and, their public order, and we don't want to, we want to give the legislature sort of the widest latitude to preserve that. Gauged by this standard, we cannot say that a law which authorizes or even requires the separation of two races in public conveyances is unreasonable, or more obnoxious to the 14th Amendment than the acts of Congress requiring separate schools for colored children in the District of Columbia, the constitutionality of which does not seem to have been questioned, or correspondingly acts of state legislatures. So because the other laws about this haven't been questioned, this law must be okay too. And also, this is a key phrase, is unreasonable or more obnoxious to the 14th Amendment than these other acts. Well, right, yeah, but that's a sword that cuts two ways, right? Because you could look at that and be like, yeah, those are obnoxious too. We just didn't figure it out for another 70 years. We consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the Act, but solely because the colored race chooses to put that construction upon it. That is a grim piece of legal reasoning, I'm afraid. That basically is saying, getting treated like this, getting put in a car, and Harlan gets to this point, but the point was not that there were like white people wanting to be like, oh yeah, I want to be in that car. It was clearly, and everybody understood it as such, to prevent the black people from getting into the cars with the whites. That's only racist because you feel bad about it, right? So the solution is not to rescind the racist law. The solution is you just stop feeling bad about it. Like, if someone drops the N-word on you on the street, just stop feeling bad about it. That's not, that's... So, whatever, like that's... once again, I realize that I've slipped into my own personal opinions, but I'm afraid that that's just, like, I can see, though personally I disagree with the idea that, I can see how you might say, well, look, this is my personal property. What I do with it is my own business. Like, I should have the right to exploit it, as long as I'm not, materially denuding the life chances of other people. They'll get to, if you take the train from Mobile to Louisville, so you have to ride in the black car, you still end up at Louisville at the end of it, right? I think that's specious, but but it's not like logically absurd. I just think it's wrong. But, but this idea that it's only bad because you feel bad about it, that, I'm afraid, does not rise to the level that American jurisprudence really would call for, I'm afraid. Harlan's defense is stinging. Harlan's dissent is stinging. This is really one of the most tightly argued pieces of jurisprudential dissent you're going to find. But it does have some interesting elements, and I'm going to get to some of them in a minute here. This is Harlan. In respect to the civil rights common to all citizens, the Constitution of the United States does not, I think, permit any public authority to know the race of those entitled to be protected in the enjoyment of such rights. Every true man has pride of race. This, I think, is an archaic idea, although some people seem to be trying to regenerate. But whatever, that's an issue for another time, and maybe a 700-page book that I may write at some later point. To be read by no one, but at least it'll hold my front door open or whatever. Every true man has pride of race, and under appropriate circumstances, when the rights of others, his equals before the law, are not to be affected, it is his privilege to express such pride and take such action based upon it as to him seems proper, right? So if what you're doing, this once again, I agree with that sentiment. Like, this is America. You're allowed to hold whatever idea you want, as long as it doesn't mess up the life chances of other people, right? So that's the great thing about our system, and it's what it made it very different from the European system. In Prussia, your opinion could get you thrown in jail for a long time with no habeas corpus or any of that stuff. You had to be very careful about what you said, even in private conversations, because what you thought, this is an outgrowth of the kind of religious wars, right? People got burned up for things that they believed. And that was something that the framers of the Constitution really wanted to get away from. By the way, this is why they put in very early in the process of the Bill of Rights, the state shall make no law establishing religion. Not because they weren't pretty much to a man practicing Christians of various kinds. Let's just be clear, there's a variety of Christian belief and practice among the founders. But because they had seen what had happened in England, people getting burned at the stake, people getting beheaded, people getting hanged, people having all their property seized because their religious views were viewed as being inappropriate or what have you. So, this is something that's very central to the kind of thinking of the people who put this country together. But I deny that any legislative body or judicial tribunal may have regard to the race of citizens when the civil rights of those citizens are involved. Indeed, such legislation as that here in question is inconsistent not only with that equality of rights which pertains to citizenship, national and state, but with the personal liberty enjoyed by everyone within the United States. So, once again, the underlying premise here is that those public conveyances, the trains, the inns, the theaters, there's a public dimension to them, right? So it's not just, the idea is not like, well, I can't stop people coming in to my backyard, or I can't stop them from coming into my private domicile. But if I'm running a public facility, then the state does have an issue with me limiting on the basis of race or creed or what previous condition of servitude. All right, I'm going to read a couple more passages because I think it gets some really key things here. It is one thing for railroad carriers to furnish or to be required by law to furnish equal accommodations for all whom they are under legal duty to carry. It is quite another thing for government to forbid citizens of the white races and black races from traveling the same public conveyance, and to punish officers of the railroad companies for permitting persons of the two races to occupy the same passenger coach. And that was the key thing about the Louisiana law. It wasn't just the railroad company saying, we have these. The law in the state of Louisiana was that white people and black people could not travel in the same conveyance. If a state can prescribe as a rule of civil conduct that whites and blacks shall not travel as passengers in the same railroad coach, why may it not so regulate the use of streets of its cities and its towns to compel white citizens to keep to one side of the street and black citizens to keep on the other? Why may it not, upon like grounds, punish whites and blacks who ride together in streetcars or in open vehicles on a public road or street? Why may it not require sheriffs to assign whites to one side of the courtroom and blacks to the other? And why may it not also prohibit the commingling of two races in the galleries of legislative halls or in public assemblages convened for the consideration of political questions of the day? Further, if the statute of Louisiana is consistent with the personal liberty of citizens, why may not the states require the separation in railroad coaches of native and naturalized citizens of the United States or of Protestants and Roman Catholics? Once again, exactly right. Like, if that's a legit, if the separation like that is legit, why aren't all other kinds of separation also legitimate? Like, okay, we're going to have Presbyterians here, Methodists there, Quakers you can ride on top. And this is once again John Marshall Harlan speaking as a man of his time. The white race deems itself to be the dominant race in this country, and so it is, in prestige, in achievements, in education, in wealth, and in power. So I doubt not it will continue to be for all time if it remains true to its great heritage and holds fast to the principles of constitutional liberty. But in view of the Constitution, in the eye of the law, there is in this country no superior dominant ruling class of citizens. Okay, so you could look at the white race and say, they have these accomplishments, they have this wealth and power. In that respect, you just look at it as a matter of like historical situation. That's the way it is right now. And maybe it'll be that way for all time, maybe not, who knows. But what Harlan is saying is, in terms of the law, in terms of human dignity, there is no distinction between race, right? There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. I like that line because it gets back to Thomas Rainsborough at the Putney debates. For truly I believe, sir, that the least he that is in England hath the life to live as the greatest he. That the cool thing about our system is there are rich people, there are poor people, there are people in the middle, there are whites, there are blacks, there are Protestants, there are Catholics, there are Muslims, there are whoever else, there are Hindus, there are Buddhists. But in terms of your basic human rights, in terms of the dignity that the Constitution ensures for you, there is no distinction. The Constitution simply does not recognize that. So any law that tries to create those distinctions must necessarily not be commensurate with the Constitution. And here he gets to the nub. In my opinion, the judgment this day rendered will in time prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. He's creating that link. He wants to be very clear and explicit. It was adjudged in that case that the descendants of Africans who were imported into this country and sold as slaves were not included nor intended to be included under the word citizens in the Constitution and could not claim any of the rights and privileges which that instrument provided for and secured to citizens of the United States. That at the time of the adoption of the Constitution, they were considered as subordinate and inferior class of beings who had been subjugated by the dominant race and, whether emancipated or not, yet remained subject to their authority and had no rights or privileges but such as those who held power and the government might choose to grant them. The recent amendments to the Constitution, it was supposed, had eradicated these principles from our institutions, but it seems that we have yet, in some states, a dominant race, a superior class of citizens, which assumes to regulate the enjoyment of civil rights common to all citizens upon the basis of race. The present decision, it may well be apprehended, will not only stimulate aggressions, more or less brutal and irritating, upon the admitted rights of colored citizens, but will encourage the belief that it is permissible by means of state enactments to defeat the beneficent purposes which the people of the United States had in view when they adopted the recent amendments to the Constitution. Now remember, the amendments were just not in Congress. They had to be ratified by the states too, and the only reason they could be ratified by the states was Reconstruction. Because if they tried to do it after Reconstruction, none of the black people would have gotten to vote for them. And that's just a matter of, you can see when, there's a period where Louisiana in the 1860s or 70s had a black governor. But with the end of Reconstruction, that possibility passed away. He also says, and this is, I'm afraid, an unfortunate thing, but I do like to present the sort of full scope. There is a race so different from our own that we do not permit those belonging to it to become citizens of the United States. Persons belonging to it are, with few exceptions, absolutely excluded from our country. I allude to the Chinese race. So, unfortunately, much as I respect John Marshall Harlan, he had not fully understood the implications, let's just say, of what he was saying. I think that if you follow out logically the implications of what he'd been arguing, you have to, and eventually that was resolved too, although not for a long time. But by the statutes in question, a Chinaman can ride in the same passenger coach, my apologies for using that, which is an inappropriate term, but it's in the text, so I'm going to say it, can ride in the same passenger coach with the white citizens of the United States, while citizens of the black race in Louisiana, many of whom perhaps risked their lives for the preservation of the Union, who are entitled by law to participate in the political control of the state and the nation, who are not now excluded by law or by reason of their race from public stations of any kind, and who have all the legal rights that belong to white citizens, are yet declared to be criminals, liable to imprisonment if they ride in a public coach occupied by citizens of the white race. It is scarcely just to say that a colored citizen should not object to occupying a public coach assigned to his own race. He does not object, nor perhaps would he object to separate coaches for his race if his rights under the law were recognized. But he does object, and he ought never to cease objecting, the citizens of the white and black races can be adjudged criminals because they sit or claim the right to sit in the same public coach on a public highway. The arbitrary separation of citizens on the basis of race while they are on a public highway is a badge of servitude, wholly inconsistent with the civil freedom and the equality before the law established by the Constitution. It cannot be justified upon any legal grounds. So this is, I think, a fairly straightforward statement of Harlan's objections to the Plessy decision, which unfortunately I believe that it was, I think there were two other justices in dissent at that point. These ideas would not be taken up until the 1950s again, and they would mostly be forgotten because people became, American politics, I guess, went a different way is a sort of good way of stating it. But there's one other thing I want to talk about really quickly, and this is one of the last cases that he was involved in, and it was one that, in fact, gives us a kind of bridge to our next conversation, and that is Lochner v. New York from 1905. Joseph Lochner was a German immigrant. He ran a bakery in Utica, New York. The state of New York had passed a law saying that it was illegal to compel bakers to work more than 10 hours a day or 60 hours a week. He was convicted. Basically, Lochner's procedure for baking was he would have them on the premises all the time and have them sleep there too. He was convicted. He was fined. I think he was fined $20 or something like that, which is like $1,600 in American in modern money, but you know, and he appealed. It went to the Supreme Court. The Supreme Court found that the law violated the Due Process Clause because it violated the workers' freedom to sign contracts, basically, or to determine their own conditions of employment, which is a peculiar argument. Once again, Harlan was in dissent. The power of the courts to review legislative action in the respect of the matter affecting the general welfare exists only when that which the legislature has done comes within the rule that if a statute purporting to have been enacted to protect the health and public morals or the public safety has no real or substantial relation to those objects, or is beyond all question a plain, palpable invasion of rights secured by fundamental law. Basically, Harlan was arguing that the burden of proof was on the other side, right? That you know, and I think that what it was acknowledging was it wasn't like the workers were being like, I would love to work a 60-hour week. You know, I really feel like, you know, 10 hours a day is just not enough to bake bread. Now, once again, you can kind of see the other side of the coin if you abstract from the world in which we actually live, right? Like, I've had jobs. For instance, I was a manager at a courier company, and I can tell you that I worked plenty of days that were far longer than 10 hours. But I also agreed to do it beforehand, and I could have said no. And it wasn't essential. I mean, partly it was because it was essential what we're doing. So theoretically, you could sort of say, well, you know, suppose there's a process that requires more than 10 hours, and the people who started have to be the people who finish it. Like, you can imagine some industrial process where that might be the case. But clearly what is going on here is not workers being like, I really want to work a 60-hour week. Clearly, like, they're in the position of, you know, not to get all Marxist on you, but some people own the means of production, i.e. Lochner, and the bakers are really just selling their labor power. And because Lochner is the one that is granting them employment, and because Lochner can also say, well, if you don't want to work a 60-hour week, if you don't want to work 15 hours a day, you know, good luck finding a job somewhere else. So there's a kind of real-world aspect to this. That being said, the Lochner court was decisive. The Lochner ruling was decisive of the Supreme Court for decades after that. And this court is often referred to as the Lochner court because the protections that they were interested in affirming were the protections of the employers as opposed to those of the the workers. But the one thing I want to leave you with here is another dissent written by Oliver Wendell Holmes. The case is decided upon an economic theory which a large part of the country does not entertain. If it were a question whether I agreed with that theory, I should desire to study it further and long before making up my mind. But I do not conceive that to be my duty, because I strongly believe that my agreement or disagreement has nothing to do with the right of the majority to embody opinions in law. A constitution is not intended to embody a particular economic theory, whether of paternalism or the organic relation of the citizen of the state or laissez-faire. It is made for people of fundamentally differing views. The liberty of the citizen to do as he likes, as long as he does not interfere with the liberty of others to do the same, which has been a shibboleth for some well-known writers, is interfered with by school laws, by the post office, by every state or municipal institution which takes his money for purposes thought desirable, i.e. taxes them, whether he likes it or not. The 14th Amendment does not enact Herbert Spencer's social statistics. Every opinion tends to become a law. I think that the word liberty in the 14th Amendment is perverted when it is held to prevent the natural outcome of a dominant opinion, unless it can be said that a rational and fair man necessarily would admit that the statute proposed would infringe on the fundamental principles as they have been understood by the traditions of our people and our law. It does not need research to show that no such sweeping condemnation can be passed upon the statute before us. So essentially what he's saying is that if the majority, as embodied by the legislature, right, so the legislature is, since it's elected by a majority of the people, notionally at least, the rules that they make are the sort of majority opinions, if you will. And it's also the case that there's plenty of cases where we interfere with the sort of decisions people make about themselves in order to promote a larger good. So I can tell you with 100% certainty that if you asked my 8-year-old whether he thought that being compelled to go to school every day was commensurate with his human rights, he would give you an unequivocal no as an answer. Likewise with taxation, I mean, I've said before, this is one of my favorite keywords, you know, no taxation without representation. Well, nobody likes taxation with representation, but taxes are the, you know, what we pay for a civilized society, hopefully. So in the next lecture in this series, we're going to talk at much greater length about Oliver Wendell Holmes, who is a much different sort of creature than John Marshall Harlan. He too is marked by the Civil War, but in a different. Harlan came through the Civil War and has a kind of post facto change of heart. For Holmes, the experience of the Civil War imbues him with this idea of the seriousness of what he's doing and the way you have to live your life. And he brings that to the court in a way which is really profound and really interesting. But that's what I have on this topic. Thank you for listening, and if you have questions, I might be able to answer them. Thank you so much. I hope to see you at the next one, and tell your friends, because Oliver Wendell Holmes is possibly, I think he's one of the 3 or 4 most interesting Americans, but, you know, come hear what I have to say and maybe you'll agree. Or